I want to bring in Harvard Law School professor emeritus Laurence Tribe, a constitutional law expert. I do want to kind of linger on this, the concurring opinions and the dissent within them for just a moment, because just pulling out some quotes from the concurring opinion by the three liberal justices, they're pretty explicit. They say that by resolving these and other questions, by saying Congress has the authority here, not the states, the majority attempts to insulate all alleged insurrectionists from future challenges to their holding federal office. Explain that concern from those judges.
Thanks, Katie. I think it's a very important concern. After the Civil War, the Constitution was amended to make sure that anyone who is engaged in an insurrection against the Constitution, as it appears Donald Trump did, any such person could not seek any public office again, certainly couldn't hold public office. The court says, well, that may be, but unless we can get a congressional statute, that is basically a dead letter. Unlike other parts of the 14th Amendment, which can be enforced in any number of ways, this central provision, which is designed to prevent people who try to overthrow the whole Constitution from having another go at it, this crucial provision is a dead letter. The four justices who thought the court went too far in that respect, the four women on the court, were all in agreement that the court went way further than it needed to go. And in particular, the three liberal justices poked a finger in the eye of the Chief Justice by quoting back at him what he had said when the court, in the infamous Dodd's ruling, not only got rid of Roe v. Wade, but essentially got rid of all protection for women's reproductive rights. In that case, Chief Justice Roberts thought that the majority had gone too far, and he said that when the court decides more than it needs to decide to resolve a case, then it is acting not like a court, but basically like a super legislature. That's what the court did in this case. And it left basically unenforced, and for all practical purposes, unenforceable, the Constitution's main protection for democracy when it is threatened by a would-be dictator who tries to overthrow the Constitution, stay in power beyond the end of his term, doesn't quite succeed, and then tries again.
You say...
Right now, yeah, go ahead.
Yeah, no, so you say it's basically unenforceable. The court is saying that Congress needs to pass a statute. Can you explain the mechanism here? Explain how that would work.
Well, in fact, we're going to see it in real time. Jamie Raskin, Adam Schiff, a number of others have worked on a possible law that Congress could pass, and no one doubts that it has the power to pass it under the part of the 14th Amendment that says Congress has the power to enforce the provisions of this amendment by all appropriate legislation. So if we imagined, and it takes quite an imagination, a Congress that was really functional with someone other than Mike Johnson as Speaker of the House who would allow a majority to work its will, we imagine a Congress that could act like a normal Congress, then what it would do is pass a law that would provide a mechanism very much like the one that Colorado used, except it would be one for the nation as a whole, by which a would-be federal official is challenged before the election, not after the election, which would cause chaos, challenged on the ground that that official, having taken an oath to uphold the Constitution, tried to overturn it by not accepting a loss when there is a fair election that tells that person your time is up, you've got to go. That would not be a very hard statute to write, except when you have a Congress that is dysfunctional and unwilling to write about just about any law that does anything. What you're basically saying is the country is hostage to someone who engaged in insurrection, and notice nothing the court said today denied the claim that Donald Trump did just that. They leave that question open. When you have someone who tried to overthrow the Constitution by saying, I may have lost the election, but I'm going to figure out a way to stay in power anyway, that person can try again. And the belief of the authors of the 14th Amendment that allowing voters to get basically snookered into giving that sort of person power is not an adequate remedy. You need to disqualify such a person. But if Congress can't get its act together, then the person can just ride on the fake information that he or she may propound in order to get elected.
Can we talk about immunity and what this might signal? So what we see in the concurrence from the three liberal judges is a line that reads like this. In this case, the court must decide whether Colorado may keep a presidential candidate off the ballot on the ground that he is an oath-breaking insurrectionist and thus disqualified from holding federal office under Section 3 of the 14th Amendment. Should we read into anything at all that they're using an oath-breaking insurrectionist in their concurrence?
Well, I think it would be a little much to say that they are definitely saying that that's true about Donald Trump. But what they are saying, I think, resonates with what the court did in the immunity case. They're saying that the court is leaning over backwards in support of someone by deciding more than it needs to decide. In the immunity case, all the court needed to pose as the question presented is whether someone charged with the crimes that Jack Smith has charged, that is the crime of trying to steal the election, which is sort of a non-lawyer's way of describing the many parts of the Smith indictment in D.C. The question is whether someone charged with those things can plead, oh, I was just doing my job as president. That's really all the case presents. Instead, the Supreme Court is going to drag it out by transforming that into the broad question of whether and to what extent anything that a president does while in office can be permanently immunized from prosecution on the basis that it's alleged to fall within the scope of his duties. That's a very broad and general question, and the court could well decide, in the case we're going to hear argued during the week of April 22nd, it could well decide that that issue has to be remanded to the D.C. Circuit and then to Judge Chutkan before we can ever try Donald Trump for the things that he is charged with having done. So that even though in the end we know that presidents can't possibly have the kind of absolute immunity that Trump claims, we won't be able to put him on trial until after the election. And if he should win that election, he will certainly make the whole case go away.
Well, let me ask you, hold on. When you say remanded back to Judge Chutkan, is that to decide the scope of presidential immunity before they decide whether Donald Trump violated the law with what he did on January 6th?
Exactly. It would basically require Judge Chutkan to decide something she has not yet decided, and that is which of the precise acts that a president might commit that violate various criminal statutes are within the outer perimeter of his presidential duties. That's not an easy question to decide, and to say that she basically has to lay out a roadmap for all of the issues of presidential immunity before Donald Trump can go to trial is like saying, we'll wait till hell freezes over. That's not going to happen anytime soon. And so just as in this case, by taking on more than the case actually required, the court was indirectly allowing the former president to drag things out so long that for all practical purposes, he gets immunity, even though everybody might agree that what he did in trying to stay in office, even with violence if necessary, has no appropriate immunity under the Constitution.
So you're saying that's a possibility. If they were to remand it, I mean, they could also decide for themselves where the immunity lies. They could make that definition themselves at the Supreme Court, correct?
They certainly could, but that would only happen if they were eager, if there were 5 justices that had any eagerness to get that case done before the election. And we know they're not, because by postponing the argument until the week of April 22nd, when it could have been argued much sooner, just as the court in Bush v. Gore argued things basically from one day to the next.
Yeah.
By doing that, they made clear that they have no interest in getting that case resolved. So the court, in these indirect ways, is showing that it is tilting the playing field in support of the former president.
Laurence Tribe, it's always good to have you.